SJC-13505, Commonwealth v. Juvenile.
Okay, Attorney Coase.
Good morning, Your Honors. May it please the Court, my name is Matthew Coase, and I represent the juvenile defendant. To comply with Article 26, this Court held in Perez 1 that a juvenile non-homicide offender could not be sentenced to more than 15 years of parole-ineligible incarceration unless there is a finding of extraordinary circumstances after a Miller hearing. For this juvenile defendant and a handful of other juvenile defendants sentenced after Perez, the addition of straight probation to their revised sentences is illegal. This is because any sentence following a probation violation is essentially just a deferred component of the overall aggregate sentence or aggregate punishment that causes the bottom number of the sentence to increase above and beyond the 15 years that's permissible under Perez.
What causes that to increase above and beyond what is allowable under Perez? Isn't it the violation of the probation that causes that, or is it the probation?
It is, Your Honor. It's the violation of the probation, because what we're talking about is the parole-ineligible incarceration.
Right, so if the cause is the violation of the probation and not the probation itself, isn't it different than what was not allowed in Perez 1?
I disagree. I think
Can you explain why, though?
Yes, sure.
If you agreed, we wouldn't be here.
In Perez 1, the court looked at the entire aggregated sentence that Mr. Perez had. If you look at footnote 2, there is a series of concurrent and consecutive sentences, and it did include a 10-year term of probation in that sentence. So essentially what happens is the court in Perez set a bottom number. It left the top number to the sentencing judge in their discretion, but anytime that bottom number comes above 15 years, it's presumptively disproportionate, and it triggers a resentencing hearing. That sentence cannot stand until there's a finding of extraordinary circumstances. So
But that was because it was beyond, your parole eligibility date went beyond 15 years. This person's out after 15 years. Isn't that totally different?
Well, I think the problem lies because of the differences between parole and probation. A sentence that involves parole, if someone is released and they go out onto parole, if they violate parole, they're brought back in on the original sentence because they violated parole. On probation, if someone violates probation, they can be resentenced based upon the underlying conduct. And therein lies the problem. For example, in this particular case, the juvenile defendant, he can be resentenced on any of those terms of probation. There's several of those offenses are life felonies. And if you were to be resentenced to life after a probation violation, he might not be parole eligible again for another 15 years. And now he's in a situation where he's served 30 years until he's parole eligible, which is far beyond what is allowed for under Perez.
So can we go back to first principles? Why is it that juveniles can't be sentenced, cannot have a parole ineligible sentence beyond 15 years? What was the basis for that in Miller, et cetera?
Well, the basis in Perez was that was proportionality. If you compare a juvenile non-murder defendant sentence to a juvenile murder defendant sentence, it can't be disproportionate. And the way that the court calculated that proportionality was by looking at the parole eligibility date. Again, the top number for juvenile non-murder defendants is left to the discretion of the sentencing court. But any time a juvenile non-murder...
But I guess going back to first principles, isn't it because juveniles are different, children are different than adults, and we treat them differently than adults because of the prospects for rehabilitation, things that are beyond their control in their immediate environment, unlike adults? You know, those four factors that really gave rise to this whole jurisprudence. How can you look at those factors and tell me how it is that those factors require this sentence to be unconstitutional?
Well, it's a combination of the factors of involving juveniles, but it's also a combination of the fact that we're not dealing with a murder offense or a homicide offense. And children or juveniles
So
who do
let's
not...
stick with the former, right? Now, I get this is not a homicide offense, but looking at why children are different for purposes of punishment, can you look at those factors and tell me why probation like this is unconstitutional?
It's unconstitutional because it's a punishment of the original underlying offense.
But that's not why it's unconstitutional. Why, you know, the fact that children are different, tell me something about how children are different that makes this straight probation unconstitutional. Right, like look at rehabilitation, right? The sort of as one factor, right? Children change. We know that from the science. Their brains are different, more likely to be erratic behavior, subject to peer pressure. How does that inform whether or not straight probation for non-homicide is unconstitutional in your client's case?
I think it's because at a certain point, there becomes too much punishment. Because of these factors for juvenile offenders.
How is letting somebody out into the community on probation similar to incarcerating somebody for life?
Because the exposure to additional parole ineligible incarceration puts the sentence into...
But that you're talking about the proportionality between homicide and non-homicide. I'm focused on why children are different and how giving a child the opportunity to grow up in the community and either violate probation or not is impacted by the Miller factors, the Graham factors. How do we analyze that?
Well, I think moving forward, I think in this particular case, we're talking about a very unique set of circumstances about an individual who was incarcerated, spent a substantial period of time incarcerated, and then was placed onto probation. Moving forward with juveniles, that can all be taken care of and encompassed in the juvenile sentencing in the juvenile court. There are many dispositional options.
I guess maybe you don't have an answer to this, and I can ask your opposing counsel. How is it that these things that science has identified that make children different, how is giving the child an opportunity to be in the community by probation, how is that not considering those things? Do you understand my question? You know, like the fact that they're not in control of their environment, that they might be more subject to peer pressure than an adult, that they are more likely to be less than thoughtful in their conduct. How is it that leaving them to probation violates those principles?
I don't think that it would violate those principles. I think it would be helpful to most juveniles. And I think community supervision would be appropriate in certain circumstances.
Isn't this a one-off in a certain way? I mean, your client asked for probation. It helps sell the change. Then now, 15 years later, he violates probation. He's 33 years old. So we're not dealing with anything related to juveniles at this point. And I mean, are you saying, by the way, that every time someone gives probation now after the 15 years, we need a Miller exigent circumstances finding? Is that, I mean, it's going to be easy, right? Someone like your client, had this issue been joined, there would have been exigent circumstances for this. It's not a difficult thing, but no one contested it and no one litigated it. It just seems like we're dealing with sort of an odd case here.
Well, I agree that this is unique circumstances. I think as the amicus brief points out, we're only dealing with about 4 or 5 individuals who find themselves in this particular circumstances where they've been resentenced after Perez, and they find themselves with probation and have an exposure to more than the...
Is it your argument that whenever someone gets probation, we're going to need an exigent circumstances finding justifying that going forward? I understand you didn't bring it up, they didn't contest it, it sort of happened. But going forward, is that going to be a requirement each time?
I think it would be a requirement if a juvenile is sentenced to an adult sentence that requires more than 15 years of parole, ineligible incarceration. I think that there are many different ways that it can be structured to if a creative sentencing judge can get around that and put community supervision. If I could give the court an example.
I mean, I'm just trying to get a sense of what this case is really about. Because when you violate parole and you go back, you're back in prison. When you violate probation, you're back in prison because you blew your second chance. Both of them are the same, right?
Well, I disagree. I think when probation is revoked and parole is revoked, you have different consequences.
But you're back in prison and potentially for a long period of time for something you did when you were no longer a juvenile. You did it as an adult, which is just what we've been emphasizing, the importance of a second chance for juveniles based on the brain science, but we haven't been emphasizing that it's a violation when someone does it as an adult.
Well, I think that the case law is clear that we're looking at the sentence at the time it was imposed as a juvenile. So I think you can't separate that from the analysis because we are dealing with essentially a juvenile sentence. That's where the sentence was created.
Counsel, could you please, sorry to interrupt, could you please address what you think the nature of the extraordinary circumstances inquiry that you're suggesting should occur at the time of probation revocation? Because I don't think that's been discussed. And in your answer, could you address the fact that there's already been a finding, although it was not requested by the Commonwealth, about extraordinary circumstances here?
Correct. So that's correct, Your Honor. I did propose that in my reply brief. I suggested that there would be an alternative solution to this problem and essentially give the Commonwealth another opportunity to make a finding of or demonstration of extraordinary circumstances.
But can you just address particularly the nature, the ordinary extraordinary circumstances inquiry is supposed to take place at the original sentencing, where the judge is looking forward into the future saying, do I think there are extraordinary circumstances to believe that this juvenile should be sentenced to longer than 15 years? How should a judge even think about that inquiry at the time of a probation revocation hearing?
Well, I think the sentencing judge can take a broad, holistic approach to the sentencing at the time of the revocation. I think the cases like Costa and even Perez too suggest that post-sentencing conduct can be considered as part of that decision-making process. And I think in these particular circumstances, if the court wanted to include that post-sentencing conduct as part of its decision-making, it could.
How is that different from just sentencing the defendant on the probation revocation?
I think it's different because the court will still have to take into account the characteristics of youth, the individual's personal circumstances in addition to the nature of their crime, and perform that balancing test and determine whether or not the extraordinary circumstances are there. Even after a probation violation, the court might determine that there is not extraordinary circumstances and might find that further incarceration does not benefit the juvenile or benefit the public.
Will it benefit the juvenile if you take away from a juvenile sentencing judge the ability to include straight probation? Because judges do this all the time for this reason. And what you're going to force, if we were go into the world that you're advocating for, is juveniles are just going to get hit with sentences. They're just not going to give us a count with straight probation for the future. They're just going to give them a custodial sentence and that'll be it.
Well, I'm suggesting that, straight probation certainly isn't off the table. The Commonwealth always has the opportunity to request a Perez hearing and make its demonstration. I would also suggest that this problem can be avoided by using suspended sentences a little bit more creatively. A situation, for example, this particular case, a judge might consider giving.
You'd need extraordinary circumstances to justify that beyond 15 years, wouldn't you?
The 15 years of the parole ineligible incarceration. Again, I'm talking about the bottom number here. The judge always has discretion with the top number on the sentence. So in terms of the example.
But I'm confused, though. If the judge thought, okay, these are serious crimes, I'm giving you the full 15 years, but Diachenko and Perez 1 and Perez 2 put limits on the ability to provide for more. But if they give you a suspended sentence over 15, you need extraordinary circumstances, right? The same way I think you're arguing you need extraordinary circumstances to justify probation, straight probation, any kind of probation afterwards.
What I'm suggesting to the court is that there could be a range. For example, like a 12 to 18 on the incarcerated portion of the sentence, and then do a suspended sentence for 3 years. And then that way, if probation is violated, you're able to have the 15 years of parole ineligible incarceration. You could even do a sentencing range on the suspended sentence as well to kind of keep that in context. But I think overall, my point and the reason for this case is, Perez says what it says. 15 years of parole ineligible incarceration is unconstitutional. And sometimes the constitutionality of the sentence must overcome or supersede the judge's well-intentioned desires to place the juvenile on probation. If there's no further questions.
Okay, thank you. Attorney Steinfeld.
Thank you very much. Good morning. May it please the court, Kenneth Steinfeld for the Commonwealth. I'd like to begin by first addressing Justice Kafker's question about what this case is about. It's obviously about this defendant and the few defendants like him who are similarly situated, whose cases are set out in the amicus brief and what happens to them. It also involves, going forward in the future, what options will be available to a juvenile court sentencing judge when a juvenile has committed very, very serious offenses, and the judge has to determine what the best way to punish that defendant in conformity with Perez and protect the public is. So if he wants or she wants to give the maximum parole ineligible time, whether it's 15 years or not, if it happens after, now of course it's different because of the statutory amendments in 2012 and 14, but assuming that it's the 15 years from before that, if a judge is concerned with what to do in the future, that judge has to have the flexibility to sentence a person to probation. Otherwise, as Justice Georges has pointed,
He or she can do that if they find extraordinary circumstances.
right, but I think
But you're arguing you don't. Are you arguing you don't need extraordinary circumstances to provide for probation?
absolutely do not.
Yeah, that's what I thought you.
Yeah, no, that is my absolute point, and I think that it's no secret or surprise after Perez too that the bar is very high. This court had said for when that occurs, when there's no reasonable possibility that a juvenile can be rehabilitated within the time that it would take for a first-degree murderer first to be eligible for parole. So I am basically talking about most cases, I think it's true, in which the Commonwealth will not seek or be able to show extraordinary circumstances. Those are the cases that I'm talking about. That this case, this court's opinion in this case will have an effect on what does a trial judge do in that situation. And I think it is far more beneficial to the juvenile and to the public that that judge be able to put him or her on probation rather than give a 50.
Agree with you about the huge value of probation, but what I'm not sure of is whether you need extraordinary circumstances or not, because isn't that probation on top of a sentence that is greater than you would get for murder? Am I wrong on that?
Well, I don't think it's on top of or greater, because a murder defendant, a juvenile defendant, will be on parole when he gets out for the rest of his life.
Right, but then it's that difference between parole and probation. I don't know if there's a meaningful
Right.
difference, but there is a difference.
Well, I think that the duration is certainly shorter. If you're on parole, after serving a sentence with life parole, you're on parole for life. Whereas if you're on probation for 5 years, 8 years, 10 years, whatever it is, and then you're done. And of course, all that you have to do to avoid being sent back to prison is not break the law or violate the terms of your probation. So I think that it's a key component, and that the probation has to be part of the tools that are available to the sentencing judge.
Counsel,
and,
but-
of course,
Counsel,
I'm sorry, I was going to say.
Counsel, because could you address the point that because some of these offenses on which he's being sentenced for the first time because of the probation are life eligible, he could actually receive a much longer sentence? Could you address that point, which is different, I think, than the parole situation?
He could, but only if, as a biologically mature adult who has not been rehabilitated, then commits further offenses. That's why I think I was talking about Justice Wentland's references to first principles of why we have these rules, is because of the lack of maturity, the vulnerability, and the character not being formed of a juvenile, which were the animating principles of those cases are simply not present in a situation here where you have a juvenile who is at least in his or her 30s at the time when he or she gets out.
So
and then
that all
commits
makes sense to me, but does this mean that we'd be overruling Perez? Perez 1?
Well, absolutely not. I think this is a Perez case. I think that if this court goes back to the holding in Perez, and I apologize for reading, I'll do it very briefly. This court was very clear what its holding in Perez was. We conclude that where a juvenile is sentenced for a non-murder offense or offenses, and the aggregate time to be served prior to parole eligibility exceeds that applicable to a juvenile convicted of murder, the sentence cannot be reconciled with Article 26 in the absence of extraordinary circumstances that warrant treating the juvenile more harshly for parole purposes than a juvenile convicted of murder. And if you have, say, if you compare a juvenile rapist and a juvenile murderer, and both commit the crimes in, say, like in this case, like in 04, and convicted in 07, so we're talking about 15 years, the juvenile murderer will get the maximum parole time he's not eligible, and then he'll be out on parole for the rest of his life, which could be 30, 40, 50 years, whereas the probationer, the juvenile rapist gets the same amount, the maximum parole ineligible time, but then is only on the hook for a very small number of years. Therefore, I don't think that it's fair to say that a juvenile non-homicide offender, in this case an aggravated rapist, has been treated more harshly than the juvenile murderer. It seems to be clear and obvious that the juvenile murderer has been treated more harshly because of he's on parole for the rest of his life.
Counsel, could I ask one question, though, the foundational question? So if the straight probation count on the violation and the court holds the hearing, finds the preponderance, and says that they're going to now, on the count that the original sentencing judge gave straight probation on, now is going to impose a term of years, does that sentence go back to the original conduct for purposes of Perez?
Well, it goes back to the conduct because he's being sentenced
Sure.
to the underlying. It does not go back, though, to the original sentence. There's no reason to add the term of years that were imposed as a result of the probation violation to the initial term of years. As I said in my brief, the defendant essentially wants to relate back, take that time, that should he ever get it, to automatically add it to the time that he got for the parole ineligibility. Therefore, you need extraordinary circumstances. And I don't think the case law or logic supports that position, that it should automatically be added on, because as this case said, it talks about the aggregate time to be served prior to parole eligibility. Well, here, we don't even just have parole eligibility. He was released. He got 15 to 15 in a day, so he's on the street, which is an even superior form of relief than having access to parole. So I don't think there's any basis to add time that was imposed as a result of a violation, as I say, by a biologically mature, unrehabilitated defendant, to add that time to his initial time. Of course, this court can say that Article 26 prohibits that. There's nothing to say that, but I don't think the law, as it now stands, says that at all. And I think Perez would imply the opposite. So my answer, this is absolutely a straight Perez case. Well, I'm not asking this court to do anything to Perez or to change it at all, just apply it. And here he got probation. Otherwise, the probationary terms which were imposed initially and during the resentencing are meaningless, because as the amicus says, the only possible punishment that you could get for those would be time served or guilty filed. And that's not that's not an incentive for the defendant to behave at all while on probation. That's a nullity, that's void. So that doesn't really mean anything to putting someone on probation. So to adopt my brother's argument, you would prohibit a juvenile court judge from ever placing a defendant who got the maximum parole ineligible time on probation, which I think is both bad policy and not.
You could do it by requiring the exigent circumstances finding.
Yes.
Right. You could
Well, but
it's not that hard, but you could do it that way.
Not that. Well, the standard set out in Perez 2 seems pretty hard to reach, and it says it'll be a rare case in which it happens, and I agree.
You're right.
That's the standard. So I don't think, and that's why in this case, the Commonwealth chose not to exercise its discretion not to. It may have if it sought to, but it determined that it didn't. So, but in some cases.
Here's my question for you is, so I understand the sort of idea of letting the juvenile grow up in the community, and if they violate probation, they're presumably an adult, as in this case, at the time. But at the end of the day, if you take a snapshot post-violation of probation, we are giving a juvenile defendant for non-homicide more parole ineligible time than the homicide defendant. And just, if you take that snapshot, and it does seem odd to me that that would be okay under Perez 1.
I don't think you're giving him more parole ineligible time. You're giving him new parole ineligible time. It's not the same. You don't aggregate them or add them. I think that's a fundamental, I don't know if it's a disagreement, but that's my position.
Why not? As a practical matter, the defendant, the juvenile defendant, is going to be serving more time.
But only because there was, you might think of it as a superseding intervening cause. He has violated the law here very seriously, which makes him eligible. And
And he got out, as you said. He got better than parole.
He got better than parole.
And then he blew his second chance.
He got the very next day, and then about 6 months later, he was arrested and charged with some very, very serious crimes, which he's now being held as dangerous in the Suffolk Superior Court. Also being held on a probation detainer in this case as well. So, yeah, it is entirely within his control or her control if he violates the law or not. And of course, if the Commonwealth can't show there's a violation, then he will be free. But if it can, it should have the option to protect the people. He has demonstrated that he has not been rehabilitated if there's a violation that is found. And therefore, while he once, when he was a juvenile, had an enhanced amenability to rehabilitation, any defendant here in this circumstance and situation has shown that he's actually not rehabilitated. So I don't see any reason why he or she should not then be sentenced to to prison time for something that he was never sentenced on before. And I just fundamentally disagree that the term of years that's imposed for a violation probation should be added to the initial 15, because so much has happened since then that takes it outside the realm. The vice that Diachenko, Perez, and Miller.
You're confronted with the technical problem that he's being, when he's violated, we're resentencing him on the original conduct. So there's at least a technical appearance that it's a longer sentence for the original one. But
That's exactly right. But I would argue that it is purely technical, not a meaningful substantive distinction that should make this violate Article 26. I absolutely agree that that is something to be considered. The fact that he's being sentenced for the for the initial offense as to which he got probation.
Yes, does it matter if it's straight probation versus the alternative? So if he were given a suspended sentence of 2 years, it looks more like it's on the original, right?
Yes, it does, but I think the same principles would apply. I haven't given a great deal of thought to what the implications of getting a suspended sentence were, as opposed to a straight probation as here, but I think it's more common now, although I can't say for sure that the straight probation is the scenario that happened here, and obviously I think that's the one that's most obvious and most often, and it's the one that we're concerned with rather than a suspended sentence, but I don't see why the same principles wouldn't apply to those as well.
I understand why you're saying it's sort of technical, that the case law considers him to be being sentenced for the first time many years later, but it seems very not technical in the sense that he may get an extremely long sentence, and that sentence is for the conduct that he committed as a juvenile, correct?
Right, but it's only triggered, as I've said, by his post-release conduct.
But he's not being sentenced for the post-release conduct.
he's not.
That is the subject of a separate criminal matter on which he could receive a sentence that would, with respect to which he would not get any sort of special treatment as a juvenile.
Right, that's absolutely true.
So can you talk about, just briefly, about what is the function and meaning and limits of the idea that he has never been sentenced before? Because I think that's the basis of the disagreement about whether to aggregate here.
I think that's a bit of an issue of first impression here now, actually. It is sort of sui generis as to what that means practically, as this court has said many, many times, being sentenced for the underlying conduct. It's a fact that I can't avoid, and I don't have any better answers than the ones that I've given so far as to why it shouldn't matter for Article 26 purposes. The fact that he later has committed a crime, that's my answer to that question. That's what separates it. But it's true that he is being sentenced for the underlying conduct. I can't escape or avoid that. I don't know if I have a more satisfying answer to that question, Your Honor.
Could you address, Justice Stewart, if you got a really long one, does that, so you get 10 more years, does that create a problem? Does it not become technical if it's, or 15 years, or, does that change things?
I don't think that the term of years...
Without a finding of extraordinary, again...
Right, of course. We're all talking about, I'm only talking about a case in which there's no extraordinary circumstances where there's given probation and a violation.
And then there's, as Justice Stewart's just proposed, and then a long new hit.
Right. Well, the...
What's your answer to that, why that isn't a problem? Because that does seem more than a technical issue.
Well, but it is a function, of course, of the crime that he has committed afterwards. But
we're sentencing him not on that. We're resentencing him on his original, but giving him a big...
If that happens, he can still argue. He doesn't have to rely on the presumptive disproportionality of Perez and Diachenko. He could then make an argument that under a Cepalonis analysis, that sentence would be disproportionate. And I think that's an outlet that he would have then at that point. If he gets a whopper of a sentence on probation, he can make a straightforward, the tripartite Cepalonis analysis separate from. Here we are only talking about the presumptive disproportionality that arises when a juvenile non-homicide offender is sentenced more harshly than a juvenile homicide offender. So I think a straight argument then would be something that could be litigated if he gets that punishment at that time. If he gets a life sentence or 20 years or whatever, then he can make that argument and he has a chance to win on that. And this court might be amenable to that sort of a situation. But in the ordinary run, if he gets a 3 to 5 or if he gets, something less than that, then I don't think it's a problem. But if he does, as I said, get whacked, then he has this alternative option of a Cepalonis claim.
Well, I thought Perez 1 was all about Cepalonis.
Well,
The whole analysis is about the
adopts the
tripartite.
analysis when determining, but its holding is that if it's more harsh, then it is presumptively disproportionate. And here, in a
But it uses the Cepalonis three-part test.
right, to get the presumption.
Yeah.
So if that presumption no longer applies, which I say that it would not apply if he's being sentenced for a probation violation, he can then argue that rather than the presumptive disproportionality, his whole sentence, that includes both the initial and the probation sentence, would itself be disproportional, separate from the presumption. I'm not sure if that answers Your Honor's question.
I'll have to diagram it out. It seems like you're saying
Well,
Cepalonis under the gives you a presumption, and then Cepalonis allows the defendant to make an argument on violation of probation. Is that what you're saying?
Right, because Cepalonis is just a general
Of
framework
course.
for determining when a sentence violates Article 26 or the Eighth Amendment.
Right, but Perez 1 says you can't give parole ineligible time beyond the 15 years to a juvenile non-homicide defendant because under that tripartite test there is this presumption
Yes, exactly.
that because he's a juvenile, that these scientific factors in the brain development require extraordinary circumstances. And I guess what you're saying is that the Cepalonis argument would then apply in the violation of probation in the absence of any analysis of the juvenile circumstances?
Well, in the absence of the presumption, I'm not sure what the contours of a Cepalonis analysis would look like in the future. It may take into account the fact that as a juvenile he committed the offense for which he's now being.
Well, isn't that exactly what the defendant argues in the reply brief, that that's where it should, that something like that could happen?
Well, but I'd say that's only if he gets hit with a sentence that is so harsh that he can argue with a straight face that it is standing on its own disproportional rather than totally relying on the presumptive disproportionality provided by Perez.
Because Perez said you're entitled to this chance, this second chance, right? That's the fundamental first principle of Perez. You get a second chance at parole eligibility. But then, so you've blown your second chance, and then we're looking at disproportionality in the context of a blown second chance. I don't know, it gets complicated.
Oh, there's no doubt about that, Your Honor. I don't dispute that.
Okay.
If the members of the court have no further questions, I'd be happy to rest on my brief, and thank you very much.